I think it's working.
I got to call Rebecca and see if she'll give it a.
I was hoping you could check the streaming to make sure it's working. I can give it a try, I guess, on NC Quartz. Okay, thanks. Bye-bye. Hey, Rebecca, I just wanted to let you know I checked from NC Quartz and it is streaming is working. So, um, if you want to check the Secretary of State, that'd be great. Okay, thank you. Bye. No, I don't want it.
I have my thing all ready to be shared.
Okay.
And I just asked Rebecca, so you know, that if she could Set her phone so it doesn't go right to voicemail.
Gotcha. Okay, and I can make you a presenter.
Okay.
I checked the stream. I just sent Susan a link for the streaming.
She's what she's on. She's on the
Oh,
website, on the state site. Do you know what I mean?
no,
She's not on this WebEx, she's on the state site, the public site.
the streaming.
Yeah.
Yeah. Okay, so she already had the link.
Yeah, because it's, you just go to that website. Hey, Ray.
And Steph, you saw Judge Corpening's time constraint today, right?
Yep.
Okay.
Hi, Carrie. I'm just checking my audio.
How are you, Valerie?
I'm good. How are you doing?
Good.
Good.
Things going okay in Union?
Oh, just lovely.
How's Enterprise Justice working?
Um, I mean, if I'm being honest, it creates a lot of headaches. But I mean, there are some good qualities as well, but
Yeah.
it's definitely different.
Yes. Okay. And I should say we are streaming too.
Yes.
Okay.
I saw that in the chat.
Okay. Okay. I always like to remind people. Yeah, we have some groups that are getting ready to launch July 21st. So they're all in that phase of like, what is about to happen.
Right. We just this week we had about, I think there were 4 judges from Catawba, that district, and
Okay.
one of their staff members here. So we were going over some things with them, and I could just, it's the unknown, not knowing
Yeah.
what to expect. So I could see that fear in their face, the same fear we had.
Right. I think you just get to the point where you just have to be like, switch it on
Right.
and let's
Right.
just
Yeah.
ride it out. I guess Marcy, can you hear us? Because
Yes.
Marcy's in that last group that'll go live in October.
Can you hear me?
Yeah, we can hear you.
Okay. Yes, we are in our meetings and
Okay.
yes.
Yeah. And
I won't
it's
say
funny.
I won't say a whole lot since we're streaming.
Well, and like none of the mediators pay attention to it until they're about to go live, which I understand. You can't really wrap your head around it until, you've done some training and are figuring out what you're looking at. But it'll be good when everybody is in the same, using the same system, that's for sure.
Well, I was gonna say, at least we're all in this together.
Yeah, yeah,
And we're all trying to figure out the best way to use the system. So
yeah.
nice to have folks to reach out to see what they've learned and what not to do. And so that
Yeah.
helps.
I know. Marcy, do you have people you feel like you can reach out to?
Oh yeah, I've gone to a couple counties, um, talked to a few people,
Hmm.
gotten some of their ideas. So yeah.
Yeah. Our mediators, it's trying to set them up with somebody who has a similar setup, like whether they have a program assistant or whether they're doing live orientation or self-directed, like all that makes a big difference. I'm going to go ahead and start recording. Rick and Cheryl, did you guys do okay with the rain?
I'm sorry. I'm having trouble, I think. And I'm gonna sign on to Peggy.
Cheryl, I just tried to mute you on, you're showing up twice, so
Right.
I wonder if you're calling in and maybe we're getting double. Can you say something so we can hear?
It keeps unmuting though, Carrie. Like now
Keeps
it's
unmuting. I gotcha.
Can you hear?
We can hear you, but there's just a lot of feedback.
Yeah, I'm gonna then try to log in.
I think she said she's coming back in.
Hey everyone, can you guys hear me?
Yes.
We gotcha.
I'm
No,
gonna
no.
eat while you talk, if that's okay.
I
Shove
understand.
it in my mouth.
I just ate through another meeting.
Good afternoon, everybody.
Hello. Judge Corpening, we had Cheryl on and I think she's going to rejoin. She had a lot of feedback on her side, so she was going to rejoin us.
Okay, well, I just finished criminal court and dashed between buildings and trying to sit here and catch my breath.
That's why you're called Batman.
Some days I'm better at it than others, Stephanie.
Yeah, I understand.
All right, let's go ahead and get started and hopefully Cheryl will be able to rejoin here pretty quickly. So welcome everyone to this July, can you believe it's July, meeting of the Custody Mediation Advisory Committee. The minutes were distributed electronically by Carrie. Thank you, Carrie, for doing that. Any additions or corrections to the minutes? Hearing none, is a member willing to make a motion to approve the minutes as submitted? Don't everybody talk at once, okay?
Well, I want to know if you can hear me, so I'm going to say motion to approve the minutes.
Thank you. Yes, we can hear you. Thank you,
Yay.
Cheryl. The rest of this
All right.
crowd's so bashful today. Is there a second?
I second it. This is Nisha Williams.
Great, thank you. All right, any discussion? All in favor? Everybody's got the camera on. All in favor, thumbs up. All right, any opposed? Thumbs down. All right, minutes are approved. Thank you again, Carrie. Stephanie, updates?
Yeah, so at this point, I was going to, Carrie, stop me if I'm, I'm jumping the gun, but especially because you have to leave so soon, Judge Corpening, I wanted to talk about House Bill 612 and its ramifications for custody mediation. So I was only made aware of this like last week. And so I'm trying to catch up. And so I'm going to share my screen to show you some changes to the uniform rules that that I'm working on. They're very much in progress. I talked with Ann Terrace in our legal department about is our permanency mediation program the mediation program that's referred to in the bill. So I don't know, maybe not everybody here has read it or had a chance to look at it, but what it's looking at is post-adoption contact orders when cases referred by the county attorney, and when there is a prospective adoptive parent that the biological parent is going to relinquish to, that these post-adoption contact agreements could be discussed in a mediation program that's a court-approved mediation program. And as somebody who did a lot of permanency mediation programs in Durham way back in the day, this was often a discussion that we helped people have, but there was no way they could formalize it or count on it. The parties often agreed to some kind of post-adoption contact, but so sometimes the mediation will completely fall apart. So this is huge. And when I read it, I wanted to know right away, are we talking about our permanency mediation program? So Antara said that would be a reasonable conclusion to make. There's lots of gaps, however, and she said, why don't you try to fill in those gaps in the uniform rules? And then, I can show it to leadership here and see what they think. So I have a lot of questions about it, and I'm just kind of feeling my way forward, and I'm in the very beginning stages of looking at that. But I wanted to share with you all what I've come up with right now to add to the uniform rules for these types of mediations. Carrie, do I just hit share because I'm now a presenter too?
You should be, yeah.
I have 3 screens open. This is so fun. Okay, can y'all see this?
Yes.
Okay, so I've just highlighted anything that again, this is very rough, that I'm in the process of adding to the uniform rules to address it. So in our uniform rules for permanency mediation, and just here under agreement, I'm listing post-adoption contact agreement. Then in local administration, right now we have a form. It's not really, we need to amend it anyway. And so I'm just working on this to see what I can do to give us more information. So it's a responsibility of the referring judge to probably erase that form and complete the proper AOC forms, or provide an order informing the mediator of the issues for mediation and any limitations or parameters for resultant agreement. However, in post-adoption contact mediations, there's no order, it's a referral. So we're probably going to create a referral form because the parties are not ordered to mediation. It's voluntary and they're referred. And so then I have referred right here next in the next paragraph, ordered/referred. And then we go down to the mediation process. And here are the list of issues that for mediation, permanency mediation. So I'm creating a separate section for post-adoption contact as being one of the issues. So I quote, which I guess now it's the statute, is that right, Judge Corcoran? So
Yes.
Okay, according to this statute, this section, the court may refer parents and prospective adoptive parents to attend mediation voluntarily to discuss post-adoption contact. And all that's in italics then is the direct quote from the statute. When the county department notifies the court, it would accept the relinquishment that specifies prospective adoptive parent or parents. All right, so these are also issues that could be referred to mediation, permanency mediation. One of my questions is, or will be, maybe you all have the answer, is if post-adoption contact comes up as part of another permanency issue that's referred to mediation, can it be agreed upon, even though it wasn't initially referred for that? I feel like it can be discussed because all the professionals will be at the table and they'll then maybe fill out whatever attending paperwork. So I need to cover that as well. But that was a scenario I foresaw as I was writing this. And then the participants, and this is the tricky part for me because as Antares was telling me, and as the statute says, the parties who are referred are the biological parents, and prospective adoptive parents. As a mediator, it's helpful for us to hear from the professionals what can and cannot be finally agreed upon. And that's why, I think a form is probably going to be the best thing to alert us to what can or cannot be agreed upon in mediation. Ideally, it would be those other participants, the child welfare advocates, the attorneys, the DSS folks at the table in the beginning, but I don't think including it here is going to get them to the table necessarily. We already have a section right up here under participants that says other individuals whose input may be helpful may be invited, but I don't want to have like just one party, one of those people show up and not the other. So I'm thinking it'll probably be best to create a form that maybe starts with that county office submitting to the judge, and then, I don't know, but the mediator is going to need more information. Then it's going to be a waste of everybody's time and unfair to the parent and adoptive parent to have a discussion that's not going to be signed by the judge. So that's a glitch that I'm trying to address. And then again, we have to work on this form. I think that's pretty much it. Oh, this is the mediation session. And what I would also put in here is that just from my experience when I worked on cases like this in Durham, that if it's just the parents and adoptive parents at the table, then a caucus really has to happen at the end, at least towards the end of that session. So I would include that as well. And then I noticed in the statute under confidentiality, they have this sentence that I put in red here that maybe helps as well, that evidence that would otherwise be admissible at trial should not be rendered inadmissible as a result of its use in mediation. Just to make it crystal clear. Once I get a little bit clearer on this, then I would send it out to people as well, but I would love to hear any thoughts or feedback on this as I struggle forward with this. Cheryl, I see you writing away. Anything, any comments or help for me?
No, I was writing away because I had not seen this at all. So I was looking up to see the effective date and to see what I could figure out about it. But so no, that was the first time I've seen it. I think you've done a great job, and I promise you I'll look at it more clearly when you send it out.
Yeah, you and me both, man.
Yeah, just so many things that caught me off guard with the legislature this time.
Yeah.
Can you repeat the number, the bill number?
Well,
It's actually a session law now. It's session law 25-16.
Okay.
Yeah, it started as House Bill, like Stephanie said, started at House Bill 612.
yeah.
I was just curious about that red sentence. What does that last part mean? Just in simple terms, I mean, the double negative, so it is admissible? Or?
Yeah.
Oh,
Yeah.
gotcha.
Right above it, I think, really, I don't even know if I need that, but right above it, there's no confidentiality or privilege as to communications made in furtherance of a crime. I think that kind of gets to it. I don't know that I need the red sentence, but it was part of the House bill And so there's a couple other things in the House bill that say this language shall be included in any resulting agreement or order agreement that goes to the judge. I didn't really understand them, but certainly they'll be included. The other thing that's really important to know is that if an agreement is reached in permanency mediation, then it's turned into a civil order. And if that is going to be modified, that would go to custody mediation. Now, they have all these limitations around a modification, like the modification can only be to reduce what's in that written agreement. It can't be to add more in. So it would only be to reduce or remove any contact or anything that they had agreed upon. So I think that also has to be part of the language in any resulting agreement, so that parents would, and obviously discuss mediation, but that people signing it would understand that any modification can only be to reduce this agreement. Yeah, so it's, I mean, I heard rumblings years ago that this was something that was being looked at, but I would love to have been able to say a few things about what would have helped the mediators in this bill. So this is where, again, Ann Terrace was saying, well, you can try to fill in the gaps in the rules. I think, again, the biggest thing is, and anybody, help stop me if you think I'm wrong or you can add something in. The biggest gap I see right now is if the only participants referred are the parents and prospective adoptive parents, the mediator is not going to know very much. And then somebody here was saying, well, maybe you can get permission to look through the file. And I was like, that's just ridiculous. The files are huge, and it's not what it's not going to be helpful. What's going to be helpful, just like at AOCJ 135, is to know what the limits are. Can overnights be included? Is supervised visitation? What kind of contact are we talking about? So I think that and I also need to find out from Ann Terrace, even if the other parties were invited, could they attend? Because what the JL attorney here was saying is that he was in on some of these conversations about the bill, and that the intent was that it would just be between the family members. So what we used to do in Durham is we would have them there at the beginning, and they would help everybody understand the limits and what the limits were for and answer any questions, and then they would leave. So they were there for 15 minutes, and then they would leave the mediation, and we would mediate with the family members for a couple of hours. That would be my preference, but I don't know if I can make that happen just by putting them in the rules. It's not in the statute.
Stephanie, I think you've done a great job of taking a stab at this, especially with such short notice. I would urge you to just continue to think about it and then send out some language to the group. And then my suggestion is we come back together again sooner than our next scheduled meeting to take a look at this, because what Stephanie and I were going to update on everybody on in just a minute, and I'll just go ahead and say it out loud now. We had sent our updated uniform rules to Director Boyce for approval. But now it looks like we're going to need to resubmit. And so sooner the better, particularly since some parts of this law took effect immediately once it became law, and some parts are delayed. I'm with Cheryl. I have not read the whole thing yet.
Yeah.
So those are my thoughts about how we move forward.
Okay. And I don't know if it helps in terms of the director that it's, permanency mediation rules versus custody mediation rules, but there is a big overlap here, for modifications. So, and I've also been trying to get an estimate on how many cases we're talking about, how many potential cases we're talking about. I mean, it narrows it from voluntary relinquishment to voluntary relinquishment where there's a prospective adoptive parent, to cases where the county is referring it to the judge. But I was just talking to some people at DHHS, and they were like, wow, we think this is going to be quite a few. So, or has the potential to be you know, a significant number. So, it's just really hard to say. It could be a number that grows. I'm talking about like, and then that would mean modifications potentially. But anyway, I'm very glad that the uniform rules for permanency mediation were recently amended to allow me to train custody mediators, because otherwise that would be a nightmare. This would be a nightmare.
So, so let's, sorry,
What's that?
sorry, I'm on the landing pattern here. And those were military jets going over. They don't have mufflers. Let's plan on Stephanie continuing to work on that and then update us all and then coming back together again to look at this. Sooner the better, I think.
Okay, I'll try to get on it and finish it soon.
Other updates you have, Stephanie?
Yes, our training, September 22nd and 23rd, all is on track. We have a national trainer coming in from out of town to do a live in-person training. Carrie, I know that there's the forms that you wanted to talk about.
Yeah, I think, Stephanie, did you want to talk about the intake storage? The intake form?
Intake form. Yeah, oh yeah, just that we were trying to get some advice about how to securely save intake forms. And so I can't remember the name of the person we talked to, but it has to go to some other agency for answers to our questions. So we're still trying to get that sorted. But as we move to Odyssey, there's lots of questions about storage of things like intake forms, which have confidential information on them. And so we're slowly but surely finding people to answer those questions for us.
Yeah, they all used to be hard copies in a locked file cabinet. So next up is to update our standards of practice with that. So, yeah, I'm working on the fiscal year statistics. The fiscal year just ended June 30th, and it's been very challenging to have two different systems that we're pulling numbers from. I see Damaka. She and I have had a lot of conversations because we're both doing the same thing. So, you know, sometimes we've had 19 districts go live this fiscal year. And so we have to get numbers from CaseWise, numbers from Enterprise Justice, and combine those. And we have different codes that we're using. So we will be very happy when it's all in one system. It'll make it a lot easier. Plus, we think we have some better codes in Enterprise Justice. We made some updates to those. We still have 27 counties that remain on CaseWise as of today, but 14 will go live July 21st, and then the last 13 go live in October. So the end of the next fiscal year, then we'll have everybody on board. We sent a couple forms, and I'll try and share the custody mediation notice that we have. Let's see. Okay, can folks see that? Yes, okay. So Emily Westover, who works with BAPM, I think a lot of you have overlapped with her as your districts have gone live with Enterprise Justice. We had been working with her ahead of the initial rollout of Enterprise Justice, trying to come up with a statewide form that would work as a notice to orientation and to a custody mediation session. We had never had a statewide form because the orientation information is very specific for each district, each county. But having a statewide form allows for tokenization, the pre-population of file number, parties' names, stuff that the mediator would just have to type if it's not an AOC statewide form. So they had put a halt on creating new statewide forms for a while, but Emily reached out and said, I think it's a good time to try and move forward with this notice for orientation and or a mediation session. So we wanted to bring it to CMAC first, and then the next step would be to go through Office of General Counsel and then to the Forms Committee. But we sent this out to the field. It's really hard to come up with a statewide form that works for everyone because we have different modes of orientation. But we took their feedback and did the best we could to make it hopefully usable by everybody across the state. And they don't have to use it. We just want it as a resource. We have Wake County does orientations every week with up to 30 or 40 cases. So we have 20,000 people who attend orientation each year. Each of them get at least one notice. A lot of them get two. So making this as easy as possible for the offices is going to be really helpful. So just wanted to see if you had any questions or suggestions around this form.
Carrie, I think I know, but under session type, there wouldn't be anything pre-populated, right? The person who's filling it out would just type in whether it's orientation or a session under session type, or?
Yeah, that's a good question. I think it would be pre-populated based on whatever the hearing is titled, but I could check with Emily about that. My understanding was all of that could be pre-populated from the hearing information.
I see.
And Kristen gave a lot of great feedback, so really appreciate that.
Love forms.
All right. Well, if anybody does have any comments or feedback, just email us, and I'm going to go ahead and stop sharing this. We also sent out order approving parenting agreements. I'll pull one of those up. Actually, I'm not sure that I have it readily available. I could pull it up in just a second, but the main question was, we have an order approving a full parenting agreement. We have an order approving a partial parenting agreement. The question came up from the field, why isn't there an order approving a temporary parenting agreement? And the feedback was if the form actually said it was a temporary parenting agreement, it would be easier for the judicial staff to make sure that they, file it correctly, code it correctly in the system. So Stephanie and I were trying to figure out if there was a reason that this committee knows of that form never existed.
So part of that history connects to the fact that temporary parenting agreements were frowned on for a long time.
Mm-hmm.
So there wasn't a real push to develop a form for something that lots of folks frowned on.
Gotcha.
So I think that's probably most significant.
Yeah.
I remember a judge, the chief in Wake County when I was there, telling me that a temporary parenting agreement was not the same as a temporary order. And I didn't really understand what they meant, but They said attorneys are using that differently than you all are using it in mediation. It's not a temporary order like an attorney would call it a temporary order. I don't know if that's true.
Well, and right now, temporary agreements are just, the mediators use the order approving parenting agreement, but we want to make sure custody doesn't get closed when that is filed, because it shouldn't close custody. And you know, if we did a form, we know we'd need to include the return date for the parties. That's what we were thinking we could add into the form, because the forms are the same between the partial and the full parenting agreement, except the partial says what haven't they been able to agree on.
No, sorry, Carrie, were you talking about adding a date for return on the partial?
Not on the partial. If we developed a temporary, an order approving temporary parenting agreement, we could list the date that the parties plan on returning. Because
But
we
don't
include,
do, but we don't do that with the partial,
no,
correct?
correct.
We've had the partial for a while, is that
Yeah.
right?
Yeah. And honestly, statewide, there's probably less than 75 partials a year. They're not very common, but we have a lot more temporary agreements than we do partials.
Yeah, I was looking at that and I don't know why I've never looked at it before, but I'm kind of thinking that that partial agreement probably is a temporary order anyway, unless we put some kind of additional language in there to make it clear that it's intended to be a final order. For example, if a judge just entered an order that looked like that, the Court of Appeals would say it was temporary. So,
because it's not fully resolved.
yeah, yeah. And when I was looking at that, and how is that? So when a partial parenting agreement is entered, how is that? Does custody still remain pending after that? That custody is, you mentioned that custody, you want to make sure custody is not closed. Is custody closed when this partial order is entered?
I would defer to people
Yeah,
like Valerie and Marcy, maybe, and what
yeah,
happens in their systems.
In Durham, it's not closed, but it is, the unresolved issue is set for trial.
yeah,
And
yeah,
at that hearing, I think, even though the judge has signed the partial,
right.
the judge ostensibly has a hearing to hear that one unresolved issue or what have you. And then upon ruling on that, then I think custody is fully closed, is how I think they enter things in Durham.
Yeah,
Yeah, I think
that's
that,
how the process here as well.
That's good. That's good. And I definitely don't want to stir up issues where if everything's working and it's not an issue, we have lots of case law out there about what is a temporary order and what's a permanent order. And these, I think given what that case law says, this would probably be seen as a temporary order, which, you know, if people are interpreting it as a final thing, that's wonderful. And I don't want to stir up any problems if there are no problems. But, you know, there's a big difference between a partial final adjudication and a temporary order. So
I think sometimes what happens is also different in family court where, you know, in family court, there's a temporary agreement. They're already giving them a court date in case when they
Yeah.
return to mediation and they don't agree. Kristen, isn't this right in Durham? I know it was true. in-
The only times they will have a pretrial on permanent already set is if they've had a temporary custody hearing and before mediation is finished. So at a temporary hearing, they may schedule a pretrial, like the judge may say, oh, you haven't done mediation yet? Then I don't really want to hear this today. I'm going to schedule a pretrial on permanent for a few months out, see how mediation goes in the meantime, that kind of thing. So, but otherwise they tend to wait until they have their return session in mediation from their temporary before they go ahead and schedule the pretrial on permanent. It just kind of happens to be a little different sometimes on timing.
And what if one or both don't show up at the temporary return to mediation date?
then, I mean, luckily it's very rare, but then we mediators, will let the case coordinator know to go ahead. You know, we fill out a form saying they didn't show up and they schedule a pretrial on permanent.
Because I know that that's been an issue in non-family court districts. So like in Wake County, the date's already set in case they don't show up for the return. And then they would just cancel that day if they do show up and reach an agreement. And then in other districts, it was kind of all over the map. Is it going to stay in effect? Is that agreement going to stay in effect? Or now it's not in effect and there's no agreement? You know, that whole issue with
Don't
temporary.
the temporary ones say, maybe this isn't true everywhere, but I was thinking it is in ours that this temporary agreement remains in effect until or unless it's replaced by, you know, another order. So I
Yeah.
always tell people it doesn't expire the day you come back for your return session.
Right.
I hope that's right.
I
Yeah.
hope so too.
I need to interrupt for a second. I've got to step away. I had a colleague schedule a meeting over top of this one on my calendar, and it's about Odyssey and it's about change. So I've got to be there. I'm sorry. Judge Walzek, do you mind running the meeting for the rest of the meeting? Thank you.
Bye. Good luck.
Thank you.
I
Well, if there's not any concern about us trying to develop a temporary form, then I think we'll do that and we can bring it back to y'all. And like I said, it's going to have to go through general counsel and the forms committee. So we'll keep y'all posted.
Can I just say one thing about that, Carrie? And
Yeah.
you guys know way more about this than I do, but one thing you should keep in the back of your mind is when you do a form like this, who's going to have access to rights and rules? Because Odyssey is all about rights and rules. And I don't know who you expect to fill that form out. In some counties, like maybe family court's doing it, and other counties, I don't know if mediators have access. But if they don't put it in, who can access it? And only the
Okay.
clerk are able to do a form like that, it's not going to help anybody.
Gotcha. Thank you. That is very helpful.
That also reminds me that any post-adoption agreement is in Odyssey not going to be viewable by the public. I saw that in the bill. So, and it may, you know, I don't know how, yeah. So there's that. And then I guess if it gets modified, it's also not viewable. My big question too is how are the mediators going to know that a modification that's coming to them? And I guess maybe there's some way in Odyssey that they'll see that it's a post-adoption agreement that's turned into a civil order. But mediators will need to know that that's what they're helping people modify. All right.
Okay. I think that wraps up what I was going to cover.
All right. I forgot where we were. I'm looking up the agenda right now, but we were going to talk about update on uniform rules, or did we do, is that all
Yeah.
done? We're done with that.
Well,
So-
we were going to, and Judge Corcoran and I were going to talk about, we had sent to the director the language for allowing costs of drug treatment or drug testing to be included in parenting agreements. And I guess he has not heard back from the director yet. And so
Okay.
he wants to wait now until these other rules.
Yeah, he sort of said table it until you can look at the new bill and we can go over it again. So we can skip that, right?
Yeah.
Okay. All right. So
I'm sorry, before we move on about that language, I was just thinking about something when I was looking at the minutes, and Judge Walsek, I think you had raised the issue of making sure that the mediators were given standard language about that, or instruction to be careful about how the language about sharing of cost. Do you remember that? And you said it needs to be dealt with pretty explicitly in case there are contempt motions and that sort of thing. And the only thing I wanted to suggest was that maybe we come up with some standard form language for the mediators to use, because I think, Judge Walsey, you'll know the kind of things that need to be in that parenting agreement so that if it's easily enforceable. And I'm not sure that the mediators would have any reason to know what that language needs to be.
Yeah, I mean, I do remember talking about that. My point about it was clarity on when it has to be done, when it has to be paid by, how it should be paid. But I mean, depending on what they're ordering and what that could be such a broad range of
Oh,
stuff.
got it.
I think I was just saying in the training process, if the mediators understand that we can't hold someone in contempt unless there's a specific thing they're ordered to do, it's clear what they have to do and there's a deadline to do it.
Right.
So for example, if you were ordering somebody to split the cost of alcohol testing and you said he's going to test for alcohol and they'll split the cost, we would never hold someone in contempt for that because it doesn't say what kind of alcohol testing, when he has to pay it. But I don't know that you're going to be able to come up with foreign language that would cover all the different possibilities that you could be ordering. I mean, maybe we can, maybe something like, the parties are ordered to do X, it'll be completed by X and the cost will be split by X, and just,
Yeah.
there's so many things they could be ordering with that language, I think, drug treatment, alcohol treatment. It's a
I
lot of
like
stuff.
that.
Yeah,
like that because-
actually, that's exactly the kind of thing I was thinking about was, fill in the blanks here so that they would know just how explicit they need to be. Because if they haven't been in your position, they may not know that something other than do this and split the cost is not explicit enough. So I just thought it might be helpful. Because I agree with you. I think it'll be really hard to enforce it if it's not as explicit as the lawyers need it to be. So.
It will be helpful because a lot of times also the clients will really, really resist it, right?
Yeah.
And so the mediator can kind of get like, okay, well, you're all agreeing on this, but I think we can say, I can train the mediators to say, well, no, this was what would be required in the court order. It had to be X, Y, and Z filled in. So, and we have the training in September 22nd, 23rd, where I can share this with people. And hopefully we'll then have approval by the director for the language. So I don't know. I mean, maybe I can email one or both of you about would it look like this? Are these the things? How, why, when, where, all of that? That works.
Yeah. I don't think we need, a whole lot of language. Just I think the fill in the blanks would be good because it lets them know the category of information that you need. And
so Stephanie, what I'll send you is I have a form order that we developed for our new judges that were temporarily coming into our overflow courtroom for custody cases. And it has sort of like every possible kind of thing you could order a parent to do. And not some of it won't be applicable, but you can just look at it and see sort of what we were looking at to do to sort of train our new judges on what kinds of stuff you can offer and how you would write it.
That'd be great. Because
All
we
right.
could have like a whole additional section that has all of those things so that it can be as clear as possible. And people may need to go and do some research and then come back and tell us, Sometimes they may agree on the idea in mediation, and then they need to go and get all that information for us.
Yeah, and a lot of these kinds of things, I mean, not necessarily drug treatment, but a lot of things we order people to do have wait lists and things like that. So if you say you have to do it within 30 days, but there's a wait list that's 90 days long, that's not going to be a willful violation, frankly. So even if we put it in there, we could still put it in there and still say this is what you have to do. But if there's no possible way for them to complete a program or get through a program within the time we put down.
Right. Okay.
All right, so I'll do that after. So the next thing I have on the list is Safe Babies Court.
And okay, Polly's on. Yeah. I know she was dealing with something else earlier.
Yeah, I apologize for being a little bit late. Y'all, I was running from meeting to meeting today. So just a quick update about Safe Babies Court. It was a 3-year by pilot site. We've been able to get an extension through cost savings for a 4th year. So we're now enrolling families in Yancey and Mitchell in that district. We just weren't getting the numbers from those 2 small counties. So we're going to add Watauga, Avery, and Madison. Watauga and Avery should start enrolling in the end of September and Madison closer to the end of the year. Rutherford and McDowell just started enrolling and they're already getting families. So Judge Martell has got that up and running quite quickly. Durham, Brunswick, and New Hanover have been functioning for quite some time and are all enrolling families. Some of our sites are doing in-home and foster care cases, which I think is really interesting. I think they're seeing a lot of benefit to prevent removal from using it during in-home. The other thing that is going extremely well is having our site implementation teams, because it has every single court partner as a member on it, from a frontline social worker to the clerks to parent attorneys, JL and judge. And so they're using that to really talk about a lot of different court issues, because everything we do will impact safe babies. So we're doing a training for all of our sites. It's a virtual training, and it's going to be looking at all the permanent plan options there are for each child, what that decision, how it will impact that child, whether it be education or what financial aid is involved or visitation. So just really trying to look at all of that and get that information to them on like a one pager that they can have in court to refer to, versus choosing permanent plans for children that may not be the best option, but seems to be the path of least resistance, which we do see several of our sites working for. So we'll be doing that training in September 16th, and the response to it has been great. So we're working with DHHS to present that, and Stephanie was on that meeting earlier today with us, and we've decided now we're going to do a follow-up training with that around permanency mediation, so they'll understand that component and looking at everything for permanency for our kids. The site implementation teams are also taking advantage of that time to look at how they can improve visitation for children, what other options there are out there, trying to get some of that burden off of DSS. So they're forming subgroups with all of those court partners together to look at it. And in Brunswick, they've actually started going out and visiting all of the programs. So the judge is getting everybody together, and they're going to see what the substance abuse program is doing or what this group home is doing. And it's really bringing the community partners together and getting much more involved in our DSS cases. And that is augmented by our active community team, because one of the first things we do in each of our sites is bring together all the community resources and do a resource mapping, trying to look at availability, wait lists, what insurance they accept, what the eligibility is, where the gaps and barriers are. So we can take those concerns back to the site implementation team or the state advisory committee to kind of work through that. So that's a real quick update. If anybody has any questions, I can certainly answer them. Okay, thanks, y'all.
All right, great. Thank you. The last thing I have on the list here is access and visitation. Ms. Adams.
Good afternoon. Can everyone hear me?
Yeah.
Good. So just a few updates from access and visitation. We continue to have 5 access and visitation coordinators provide parent education. They make referrals to community resources to non-custodial parents and program participants seeking to increase parenting time and access to their children. We've recently changed the language of one of the services, which was the counseling service, by recommendation of our Office of General Counsel, just to clarify that access and visitation coordinators do not provide professional counseling. They really just ask questions to better understand the client need and assist them with available services. So we still have 4 A&V coordinator positions that are full-time. Our Cumberland and Southeast region coordinator is a 30-hour position. Recently had a vacancy in the Northeast region, which is in Wake County, that we actually just filled yesterday. So we're hopeful that that new person will begin at the end of the month. The Buncombe County position also remains vacant. That has been vacant since last August. And they are continuing recruitment efforts for that position to hopefully get someone in soon, given the static federal funding and still dealing with some challenges from the hurricane last year in the western part of the state. They have just faced some challenges with filling that position. However, we have been covering those positions. The other coordinators have really pitched in to provide services virtually in the interim. And finally, A&V coordinators continue to partner with custody mediators and their respective duty stations to provide the parent education in conjunction with custody mediation orientation, except for Mecklenburg County. They actually contract with the local parent education provider to offer parent education. Additionally, we have the access and visitation coordinators in Mecklenburg County and in the Wake County office who work in the self-serve center the self-serve center in Mecklenburg County and the legal support center in Wake County, and they are able to work with those parents who come in to those centers to receive services. So it's been great to have them available in that capacity where they can provide more services to more clients. And additionally, the A&V coordinators have begun using the custody mediation case event codes that are entered into Enterprise Justice to report on the outcomes of those cases and those parents that they see, and they can better report to us so that we can report to the federal government those cases where parenting time has increased by way of parenting agreement. So having those codes, Carrie was kind enough to provide those codes for them to begin using it so that they can get that information for reporting. We are working on the fiscal year 25-26. I'm not sure if you all are aware, but the fiscal year for the federal government runs from October 1st through September 30th of each year. So we are working to prepare the budget for the 25-26 funding cycle. So we're hopeful that there won't be any issues with continued funding for the program. And these are all of the updates I have for access and visitation, and I'm happy to answer any questions. Thank you.
Thank you. All right, I don't have anything else on the list, but if anybody's got any new business or anything else we need to talk about? All right, so Stephanie, I'm going to email you those samples, and then you're going to work on the new rules with the new bill that we got to look at, right?
Yes,
All right. Anything else? I think that's what we covered everything.
I think we covered everything. Carrie, do we have another
Do
Go
we have
ahead.
what?
date?
Well, our next meeting is scheduled for November, but I think Judge Corpany was saying
Yeah.
let's schedule one in between now and then.
Right, but that November one is already set, okay.
Yeah, so we can reach out once we'll reach out to the committee members to see when a interim meeting can work.
Probably by next week I'll have enough, I'll be stuck enough that I'll need a meeting.
All right. Well, I'll see you guys in November, I guess,
Or sooner.
or sooner.
Sooner. Yeah. Thank you.
All right. Thank you, guys. Take care.
Uh,
Have a good
bye.
weekend.